There is some drama in the Supreme Court, and it's not between the liberals and the conservatives. Two of the most extreme conservatives on the court are fighting, and two major cases between the Supreme or before the Supreme Court could be affected by this rift. The start of this is with an opinion by Justice Coney Barrett, which indirectly calls out everyone's favorite justice, Clarence Thomas. This is reporting from Politico, and it says, Thomas wrote the majority opinion rejecting the trademark applicant's claim. In the concurring opinion, Barrett used unusually blunt terms to skewer Thomas's history-based rationale for denying the trademark. She described his approach as wrong twice over, and she made clear that her gripes went far beyond this case alone. So the following expert, Barrett laments her colleagues' continued reliance on history in deciding cases. What she says is the views of preceding generations can persuade and in the realm of stare decisis even bind. Barrett wrote using the Latin term for the principle that courts should adhere to past rulings or precedents. The tradition is not an end in itself, and I fear that the court uses it that way here. In my view, the court's laser-like focus on the history of this single restriction misses the forest for the trees. Okay, but she goes even further, attacking Thomas's preferred method of interpretation, which is originalism. She says relying exclusively on history and tradition may seem like a way of avoiding judge-made tests, but a rule rendering tradition dispositive is itself a judge-made test. We're going to turn to how this may affect Trump's immunity claim, as well as an important gun case in a moment. But first, I'm curious what you make of this, Farron. Should the role of precedent in the American legal system be maybe reconsidered?
Look, I agree with her about the problem with originalism, because obviously we are a different country than we were when this Constitution was written. I mean, top to bottom, left to right, totally different. And the rules of these people that owned other human beings should not continue to bind us today. We should be able to recreate things and make them better. But in terms of the legal precedent, overturning legal precedent is what led to Roe v. Wade getting overturned. So I do think there is a role for legal precedent. It helps set it for future generations, or at least it's supposed to. But to hear Coney Barrett tell us that, oh, well, stare decisis, obviously that we have to honor. You didn't honor that with Roe v. Wade, with the Dobbs decision. You're already not doing that. So don't sit there and try to lecture Clarence Thomas about it when you yourself went along with him. I also don't know, that I make too much of this fight, to be honest with you, because I do think there's definitely real disagreements there. But at the end of the day, they both arrived at the same destination. That's like if you have two people, one of them says, hey, let's take the scenic route to the Grand Canyon, and the other says, no, I want to go interstate. Your destination's the same. So just because you got there a different way doesn't mean that you didn't both come to a bad conclusion. So again, she may disagree with the methods, but she doesn't disagree with the end result. And that's where we really need her to change her way of thinking.
Mm-hmm. Yeah, it's kind of hard to get behind someone like Coney Barrett on this, but no one's a fan of Clarence Thomas. I know this audience is not. I'm not. I'm sure you're not either. So that's easy to support. But let's talk about how this might actually affect Trump's immunity claim. The impact of the Barrett-Thomas quarrel on Trump's presidential immunity claim, arguably the biggest case of the court's current term, is harder to predict. But with no explicit discussion of that immunity in the Constitution, both sides in the case have turned to history to advance their arguments. Trump's attorneys have noted that no sitting or former president had ever faced criminal charges before Trump. Meanwhile, special counsel Jack Smith, who has charged Trump with conspiring to deprive Americans of their right to vote in the 2020 election, notes that the founders' skepticism toward executive power drew from British kings running rampant over their subjects' rights. that while both arguments are relying on history to a degree, there's not much to Trump's argument beyond that. Jack Smith is able to point to a very simple fact that the Constitution does not explicitly grant civil or criminal immunity to anyone, while the effects in Trump's immunity are a bit more debatable. In the gun control law case, it's more cut and dry. If the court adheres to a strict history-centric approach, as Thomas favors, it will likely strike down a federal law denying arms to people under domestic violence restraining orders. If she, Justice Barrett, breaks with Thomas in the gun case known as the United States versus Rahimi, and if she can persuade at least one other conservative justice to join her, they could align with the court's 3 liberals to uphold the gun control law. So the way I see it is that, at least in theory, the justices that sit on this particular bench are supposed to be the most just in the land. They're supposed to be the most rational and the most ethical and the most moral in the country. And therefore, they're supposed to be able to disagree amongst themselves and have these debates and arrive at reasonable conclusions, which is, to your point, we got to get to a good place at the end of it, however we get there. They're supposed to be able to tackle these big issues like the ones pertaining to Trump and then the gun control law. Unfortunately, the theory is very far from the practice. We know that the Supreme Court is compromised, right? We know that they're not our best nor our brightest. We know that they're an unethical bunch with really no one holding them accountable. I like seeing Barrett push back against Thomas here, but overall, Farron, do you have much faith in the court to resolve their own differences?
Oh God, absolutely not. I mean, these are 9 individuals, whether you love them or hate them, who basically are, because of the way it's set up right now, they're outside of review. There's not even a code of ethics for any of these folks up there. So they can all do whatever the hell they want because they know, first of all, they're not going to be impeached. We will never possibly, for at least 20, 30 years, have any kind of cohesion in DC to where you would have enough people to vote to impeach anyone that's impeachable, I think. So they can do whatever they want. And if it means fighting with each other, as long as they end up at that same place, then there's that. I will say this, and this is one of the benefits of not having to be the main host here. I popped onto Raw Story real quick right now, and 20 minutes ago, they got a story right here. In a case involving whether those with a history of domestic violence can keep guns, Justice Amy Coney Barrett sided with the liberal justices on the high court. Mm-hmm. So I think that answers that question. Now, I have not been able to, double check any other sources yet at the moment, but that is what Raw Story is reporting as of 20 minutes ago. Mm-hmm. So that is, I didn't think that would happen. So I am a little surprised by that. So that's where we're at apparently right now.
Yeah, she has had a few pleasantly surprising moments. I'm very tentatively saying all that, but she hasn't been as disappointing as I was maybe expecting her to be.
Thanks for watching our video. Did you know that you can support our show by becoming a subscriber? Just click the subscribe button and also ring the bell so that you get notifications when we're live or when we post new content.